the Act. There is a voluntary consumer organization. There is a group of consumers that with a special main common interest who can approach the court. In case a consumer had passed away, it could be his legal representative and higher. In case a minor, it could be their guardian or their parents. Or as my learned colleague mentioned, it could be even the Consumer Protection Authority who could file a complaint, and the state or central government. But even though there is this entire broad scope that is provided, we still need to be mindful that a lot of consumers do still come from a lot of economically, socially, and educationally backward backgrounds who might not have access to a lot of opportunities that the CPA could possibly provide them with. An example of this is voluntary consumer organizations that are legally registered are only present in major cities and states of India. Another one is it does away with the cumbersome process of filing a complaint under a court, because according to the Supreme Court's public interest litigation guidelines, even an article in a newspaper could possibly be considered and taken up suo motu as a public interest litigation. Moreover, as Professor Ashok Patil was also mentioning, the CUT survey says that a lot of consumers are not even aware of the redressal mechanisms that are provided under the Act, and hence, if PIL as a recourse is given to them, probably they can take this dispute to the court. Also, any other form of litigation, be it the adversarial form or be it the ADR, they only address issues that are specific to the parties, and the parties are representing their interests. But when it comes to a public interest litigation, the court has the leeway to look at issues that concern a broad range of consumer disputes. I will now look at public interest litigation with respect to two cases in which the court has exercised its power for the general benefit of the consumer community. One such case is the Center of Public Interest Litigation versus Union of India, where a writ petition was filed by a non-governmental organization under Article 32 of the Constitution, which allows you to file writ petitions under the Supreme Court. Here, the petitioner alleged unfair trade practice, adulteration of soft drinks under Section 19 of the Food Safety and Standards Act 2006, and also misleading advertisements under Section 2, Subclause 28 of the Consumer Protection Act 2019. It prayed for proper implementation to control the exceeding amount of additives that have been added, and also to keep a check on misleading advertisements. What is interesting here is, though the court, after getting laboratory checks done, found that there was no adulteration in the said soft drinks, it still forayed into the aspect of consumer protection and said that any product that is detrimental to the health of the consumers would go against their right to life under Article 21, as well as would be against Article 47, that is a duty of the state to provide adequate nutrition, that is a part of the directive principles of state policy of the Constitution. Another interesting case is Kandasamy versus Director of Dairy Development, Thiruvananthapuram. In this, what is interesting here is the case wasn't even for consumer protection. The petitioner had filed a case because the respondent wasn't allowing him to sell milk products in a society on the allegation of adulteration. Here, the court found that though there was adulteration, it still forayed into the aspect of consumer protection. It cited the above case and also cited Article 21 and Article 47 of the Indian Constitution, and said that it would be against genuine interests of the consumers. This is interesting because, well, one, it wasn't even for consumer protection, but since it's a PIL, and since judges have a leeway, they still forayed into the aspect of consumer protection. Coming to the comparative study, we all know, again, as I mentioned before, PILs have certain advantages that cover up the limitations that the CPA proposes. Coming to alternate dispute redressal mechanisms that are out-of-court settlements, one important part to remember is usually parties represent themselves in ADR, but if given an option, the court does allow them to hire lawyers. Important to remember that here the consumers are competing or are negotiating with large multinational corporations, which naturally have an upper hand, hence can hire expensive lawyers. Moreover, the consumers might even end up agreeing to deals or settlements that might not be beneficial for them due to intimidation and fear of the multinational corporations. Another aspect is, though PIL is a boon, we need to address certain loopholes that it does possess. One is a large number of frivolous cases are filed under PILs, and one such case is the Purchase Manager, Lanxess India Private Limited versus the President, District Consumer Dispute Redressal Forum, Madurai. In this, a seller of pallet bags had filed a PIL under Article 226 of the Indian Constitution, wherein the facts of the case are as follows. The seller had sold pellet bags that were defective, and hence the respondent had refused to pay naturally. Now, the seller took the consumer to court saying, well, you are not paying me, so this is the deficiency of service. The High Court refused to entertain the said petition, calling it blatantly frivolous because, one, you are not even a consumer under Section 27 of the Consumer Protection Act, and hence you have no standing and there's no locus standi in court. Moreover, PILs also have the scope to be misused because, well, though judges have a leeway, they need to be sure that judicial activism does not lead to judicial overreach. Again, if it does lead to judicial overreach, there is also the aspect of discouraging multinational corporations from setting up plants in India, which can be detrimental because we all know that multinational corporations provide a wide range of choices as well as employment, which cannot be ignored. A few ways that my paper suggests that these problems can be elevated is judges should keep in mind the strict separation between the three organs of the government and keep in mind that this separation is adhered to, and also they have to try to maintain a balance between the interests of the consumers and conglomerates. Since there are an overwhelming number of cases that are filed under the High Court and the Supreme Court, a small bench could possibly be set up in both the High Court and the Supreme Court to check writ petitions in advance and see if they qualify and they are substantial enough to be sent to the main bench. Consumers themselves can also be educated about consumer protection laws. Frivolous litigation could possibly be averted by imposing a reasonably high penalty on frivolous litigation. Hence, in conclusion, PILs, if used judiciously and pragmatically, can obviously be a boon and instrumental along to consumer protection along with the Consumer Protection Act 2019. Thank you.
Thank you, Asta. So we have seen our fourth presentation, Prachi Mathur on appeal provisions, Sushil Batra on special law versus general law, Siddharth Johar on suo motu powers of Central Consumer Protection Authority, and now Asta PILs, how Consumer Protection Act can be used. So all these four topics now, we are running out of time, but the discussion should be there, so that's why one or two questions from your side we are happy to, and I request whosoever present here, presenters, you can come forward, and along with you, I will also be here to answer the questions. Yes, one of you hand over the mic to them.
Good afternoon. This is Suresh Kesarkar from Ramaya College of Law. My question was about the scope of sumo motu power of the CCPA. As my learned friend told that CCPA has sumo motu power and only the central authority has sumo motu power to do things, but not the district forums. I understand the CCPA is very recent. But then as time goes, will the sumo motu powers be distributed in the district level as well. I wanted to see how this progresses in the future of our country because ಎಲ್ಲ ಕೇಸಸ್ ಒಂದು ಕಡೆ ಬಂದ್ಬಿಟ್ರೆ ತುಂಬ ಕಷ್ಟ ಆಗುತ್ತೆ ರೆಗ್ಯುಲೇಟ್ ಮಾಡಲಿಕ್ಕೆ ಆ್ಯಂಡ್ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಲಿಕ್ಕೆ ಅಂತ. So that is my question.
Yeah, thank you. So I will take up this question. So suo motu powers are given to CCPA, and when we were drafting this particular chapter, a lot of objection came from commissions, including National Commission. They are not ready to cooperate. To that extent they went. And their grievance is, when we are here, why you establish another authority? And whatever you are creating powers, establishing and giving powers, give it to us. We will do that also. So that was the discussion happened, but ultimately central government said, no, we want to establish separate central authority. Why not this central authority not established in 86 Act? When 86 Act was passed, there was another commission under MRTP Act. Monopoly Restrictive Trade Practice Act, under that MRTP commission was there. That was handling the UTP and RTP case, unfair trade practice case. That was repealed and Competition Commission Act came, and that act dropped disputes between consumer and business. Now they have taken only to business and business cartel system type of thing. Now that's why now the legislature thought of establishing the central authority. Central government kept in mind there should not be overlap between the powers of central authority and commission. Even against the decision of the central authority, aggrieved party can file an appeal to the National Commission. That power is there. And even though the central authority is there, already there are special authorities, regulatory authorities under different legislation. For example, FSSAI, Food Safety and Standard Authority of India, IRDAI for insurance, RBI for banking, TRAI for telecom. So how to coordinate between these two? The Central Consumer Protection Authority is not expert in all areas. So one of the provision is made by prima facie looking into the case. If there is a case is there, then they do prima facie investigation and refer that case to the expert regulatory authority, and they will do investigation, give that particular report. So that provision is also made. And now under the central authority there is a provision for regional central authority, regional authorities also. So that provision it is left to the central government to establish that, and even it can give some powers to the district authority also. So looking into the all these provisions, yes, the central authority can be self-sustained and they can handle all these things. And intentionally they have not given these powers to commission because past experience. They are not able to dispose of the cases within 3 months, 5 months. Then sometimes it is taking 5 years, 10 years. So it is no meaning in giving these powers to them. And under the central authority, investigating powers are also given. Investigating wing is there. Suo motu powers are there. Then even they can file a complaint to the criminal code under the offences and penalty chapter. Imprisonment powers are given. Criminal code can impose order for the imprisonment. And adulteration and spurious goods, for that and misleading advertisement offences are prescribed. So this central authority has that power, not commission. Commission is civil in nature, only to the extent of maximum compensation. But one provision is there, criminal power. If the opposite party is not obeying the order of the commission, then they can imprison. So only to that extent commission is there. So they kept everything in mind and they did particular exercise. Thank you.
Good afternoon everyone. I'm Rohit Sharma from University Law College. So my question is pertaining to the public interest litigation which was just stated. So there was an observation made at the end as a way forward that the judges have to keep in mind the theory of separation of power while adjudicating on such matters. So my question is, the very concept of the Article 32 is the overriding effect of PIL on the theory of separation of power for the protection of human rights or violation of any such rights conferred by the Constitution. So how would you justify your statement saying that the judges should keep in mind the heat of separation of power while applying the jurisdiction for PILs?
Right, so what my paper argued for is that even though I agree that I still stand by my statement that there should be a separation of powers, what my paper argued for was judicial activism should not lead to judicial overreach. Because in case that does happen, you have a detrimental impact because you also have consumers that are competing with multinational corporations. So I do agree that the CPA is a beneficial legislation, but if it leads to judicial overreach, then a lot of multinational corporations might be instead discouraged to even open up plants in India. So that is how I still stand by my statement because, well, if it does lead to, if they are discouraged, it can, one, employment, but then it can also be detrimental to the consumers itself because all multinational corporations provide you with more choice, cheaper products, employment, etc. Yeah.
Just to add on to what Asta just said, so see, PIL is in itself a very special power vested in the Supreme Court in general, right? Instead of the PIL, you also have other remedies, like you can also file a class action suit. So you obviously have that. So, and in general, PIL is supposed to be used sparingly only when you know that somebody from a disadvantaged section is coming in who can't represent himself or herself or themselves. So I think what she said does make sense because you have a lot of other remedies, PIL being only one.
And then again, you also have restrictions that could be placed for PIL itself. It doesn't mean that as soon as I come across a consumer dispute, I go to the Supreme Court or the High Court. Then why else is the Consumer Protection Act 2019 there for?
Hello. Yeah, I'm Manisha from KLE. See, now PIL, who can accept PIL is the High Court and Supreme Court only. So this PIL is only there for the National Commission, or can that be extended to the lower district and the state commissions? Now, regarding sumoto power, what the Ashok sir has addressed, is that applicable to this question also? And specific section of Consumer Protection Act 2019 which speak about this PIL.
Okay, so addressing your first query, we need to keep in mind that PIL is not a part of the Consumer Protection Act 2019. Consumer Protection Act 2019 has different suo motu powers under the Central Consumer Protection Authority, but PIL is a completely different aspect that is available for all disputes, not restricted to consumer disputes. So your PIL comes under Article 226 for the High Court and Article 32 for the Supreme Court under the Indian Constitution. What my paper seeks to say is that it could be an additional remedy, as Rushil was just saying, to address any dispute. It might not be very restricted to consumers. But in S.P. Gupta versus Union of India, Justice P.N. Bhagwati extended it to consumers as well, saying that any person from a socially, educationally, or an economically weaker background or disabled, however, if they could not approach the said commission or any other said authority that was set up for the particular dispute, there would be an option for public interest litigation. Coming to your second question, PIL as the word is not mentioned in the CPA 2019 anywhere because the CPA 2019 has its own powers. My paper mentions that PIL could be an additional remedy that comes in only when all your recourses under the CPA 2019 have been exhausted. Does that answer your question?
Just adding to what Asta said, and we are concluding first session. So under the Consumer Protection Act, one of the provision under the definition itself, complainant. So where consumer with a consumer group or consumer with the same interest, if they have agreed all together, they can file a complaint before the commission. That's the first point. Second point, central authority. If you file a, nowadays under the act, just you send a online complaint with all the supportive documents. And your complaint, if it is an individual complaint, central authority will not entertain. If it is consumer as a class, if it is affecting, then central authority will take up and they will do investigation. So the word used consumer as a class. So what type of complaints? Unfair trade practice, misleading advertisements, all these things comes under that. So that's why they have specifically used the consumer as a class in one side. And another thing, liberalization of local standi is under the Consumer Protection Act. NGOs, voluntary consumer organizations can file, and even central government and state government can file. I'm happy to share one particular thing. We did empirical research on Maggie case. We submitted to the central ministry, and we mentioned under the our covering letter, sir, central consumer ministry is having a right to file a complaint against this one. This is unfair trade practice affected whole India. We mentioned that clause also mentioned, and central ministry first time they filed a complaint before National Commission on unfair that particular Maggie case, and notice is issued for misleading advertisement Madhuri Dixit and Amitabh Bachchan under that. So in these types of things, and why we are studying Consumer Protection Act under law of torts paper. So many law schools we are teaching independent subject, one tort and another one the consumer protection laws. But majority are teaching within the law of torts. Why they have added? Law of torts, majority of the principles recognized under the statute, especially the under Consumer Protection Act. That's why they have taken under the law of torts. So with these words, I conclude first session. Thank you very much for all the four students, Prachi, Mathur, Rushil, Batra, Siddharth Johar, Asta, Malipati. All these four are first year students of National Law School 5 years course here. Thank you.
Thank you, sir, for chairing the first session, and I also thank Prachi, Rushil, Prachi Mathur, and Asta for presenting. Now I request Pratima Narayan, Dr. Pratima Narayan, advocate and mediator, founder partner, Technology Consulting LLP Bangalore, to take over the session. Over to you, ma'am. This session will address on consumer protection, specifically e-commerce sector.
Yeah, thank you, Akshay. And this is a technical session on e-commerce and consumer protection. This is specific, this is something which has come up more recently. As you see, the 2019 enactment has brought about a section on protecting consumers in the e-commerce space. The question would arise, was it necessary? Did we want to really bring in e-commerce, or is it just e-commerce or any other form of commerce? Whether I get into an offline mode or online mode, how does it matter? It's just B2C, isn't it, that we are addressing. However, there were a lot of legal aspects that were involved in a non-face-to-face transaction like e-commerce, which had to be addressed in our e-commerce, in our Consumer Protection Act. The very first question that came up was, is a consumer who is going to buy products or services online, whether he or she is a consumer within the definition of Consumer Protection Act itself. That itself was a question back then. And the second aspect that came up was in terms of jurisdiction. I purchase a product in Bangalore, the company which is selling the product is in Noida, and or maybe a service which I'm availing it elsewhere. The jurisdiction aspects came into picture. Likewise, there were many aspects that had to be considered, and what constitutes deficiency in service and what constitutes unfair trade practice. Is it any different from what happens in an offline store vis-a-vis the online store? So that is where, this is just a background of why we wanted to bring in e-commerce as a segment into the consumer protection law. We have 4 presentations in this technical session. May I call upon the first participant, Siddhant, to come over.
Hi, am I perfectly audible as that? Right, perfect. Second. Right, so I'll start off with wishing all of you a very happy and auspicious Holi. First for that. Second of all, outrightly, I'd like to thank Professor Dr. Ashoka Patil and Dr. Prathama Narayan. Thank you, Madam Sir, for offering us this stage to present before such a wonderful panel. I would like to also thank Kilpar organization and the esteemed members of the panel. Now, introduction of my paper. So the research paper that I've authored and I'm going to present before you is the consumer protection in hotels and restaurants with emphasis on e-commerce. So hotels and restaurant industry is one industry that I feel does not require much elaboration because all of us sitting here are indeed very integral consumers of this industry. I don't think so anyone here would say that they've never been to a restaurant or never been to a hotel. I think all of us have had experiences, all of us understand what problems we face, what challenges are there, what all issues or grievances consumers face or can face, because we are integral consumers of this industry. Some statistics are there. A research reveals that 89% of the population visits a restaurant at least once in a month, indicating the massive consumer base the industry enjoys. This statistic shows to us how important the hotel and restaurant industry is for consumer protection. This industry is growing at a compound annual growth rate of 13%, which is very, very fast, indicating the massive potential it has in growth. Now, I've done basic grounding for you. I'll quickly present you a roadmap as to how my presentation today is going to look like, so that it's easy for you to follow. So the paper essentially talks about a lot of things. It talks about the core legal aspects of service charge, whether it is legal or not. It talks about overpricing and a lot more grievances which have dealt with a lot of legal insights. But for the purpose of this presentation, I'll be limiting myself to the e-commerce aspect of it, as is the agenda set for the group. First thing that I'm going to talk about is the relevance of e-commerce in the industry. Second is the new draft e-commerce rules of 2021. A caveat, we are talking about 2 rules here. The first set of rules which were published and which are available to you all, like wherever you find them, are the e-commerce rules of 2020. Those were like facing a lot of criticism and people wanted amendments. That is why the ministry came up with draft e-commerce rules. These are still in the draft of 2021. I will be talking about the application of these draft rules to the industry, and secondly, I will be critically analyzing the suggestions made by FHRAI, which is the Food and Hotel Regulatory Authority of India, to these rules. Third, I'll be talking about data protection, which is a very crucial aspect. In brief, only not in much detail, provided that we're not talking about web, commerce, etc. Lastly, I'll be posing a couple of questions. First of all, pointing out loopholes in whatever the current statutory regime is, and secondly, giving you food for thought. As you guys can think as to how can these problems be solved, because these are problems that all of us can solve. So yes, that is something that, if of course, I'll be encouraging solutions if you have any towards the end of the discussion session. Right. So let's start off with the application of e-commerce to this industry. Right. We need to understand that this industry has undergone a transformation. Earlier, we were only visiting physical restaurants, we were only visiting physical hotels. Hotels, of course, are still physical. But restaurants, for the matter of fact, the industry has now transformed. Now, the players dominating the industry are not restaurants, but rather food aggregators like Swiggy, Zomato, Uber Eats, Food Panda, whatever, right? And I think all of us would agree with that. Now we're not going, these college students are not going out, we're just ordering. That is one thing how e-commerce actually plays in. Secondly, even in hotels, earlier we used to give a call to the hotel and be like, oh, I'm coming here for these many nights, give me a stay. Now we actually go to apps like Make My Trip. These are known as online travel aggregators. And because of these 2 primary reasons, I feel e-commerce has become very crucial. On one hand, while this has increased efficiency, we as consumers now derive a lot of benefits from this, but it also poses a lot of challenges, something that I'll address. acting as middlemen, these online aggregators have capitalized the market, and which has resulted in problems like unequal bargaining powers, unconscionable contracts, and exploitation of both the consumers and sellers. Remember, the exploitation is not one-sided. It is not only the consumers who might be getting exploited, it is also the sellers. Let's say the person who's supplying food to you ultimately, it's a restaurant, that guy is also getting exploited by this model, and that is something I'll talk about. Now, as I've explained to you, we'll be critically analyzing the draft rules in light of the suggestions made by the FHRAI. So, I'll be talking about two things only due to paucity of time. First is fallback liability, which is the most important thing, the most important debate in the e-commerce rules right now. What happens is that these online aggregators say that we're just middlemen. Amazon today is going to come out and say that I am absolved from all liability because I am merely a middleman facilitating the transaction between the seller and the buyer, and henceforth I cannot be held liable for anything no matter what. Understand it from the perspective of the consumers, right? Imagine a small, let's say, just take me as well, like just consider you yourself. You, let's say, buy a laptop. You do not know exactly where that laptop is coming from. Let's say you buy a Dell laptop which is being supplied by some local seller here. You do not know where that local seller is. The only thing that you know is that you have purchased it from Amazon. There's a problem with the laptop. You go to Amazon. Amazon says, bro, I can't do anything. I am exempted from this fallback liability. I am exempted from liability. Go search for your seller. Go write mails to Dell. Solve it yourself. Understand the hardships that the consumers are facing today. As a result of which, in my paper, I propose that fallback liability should be there. Fallback liability means that the liability should fall back to the middleman as well. Reasons for this, right? First is that consumers are distressed and are left lingering in the legal whirlpool, as I explained. Second is that they enjoy immense market power. Their defense is that we are just mere intermediaries not doing anything. That is wrong. They enjoy enough market power to be held liable. They are accruing enough profits that we make them liable. This argument of profits is not mine. It has been taken from a judgment. The judgment is Amazon Seller Services Private versus Dinesh, wherein the court said, it was NCDRC, so the commission said, that provided that they're earning so many profits, they should be held liable, they cannot just escape liability. Thirdly, aggregators engage in unfair practices such as arbitrary charging of service charge, charity, transaction fee. Have you often seen the donation thing that comes in Zomato? That if that is pre-ticked, that is a violation of consumer the consumer laws that we have, right? As a result of which we say that these also exploit the sellers. Last is that a lot of challenges that are faced by consumers are because of aggregators' faults. Many times you'll see that your food is incomplete. Not because the seller has sent it incomplete, because maybe the delivery man has done some issue. Many times you'll see that there is adulteration, there's pilferage, there is spoilage. Khana kharab ho jata hai. Why is that? Because the delivery man has done some issue, and the delivery man does not come from the seller, rather he is accountable to, let's say, Swiggy or Zomato. One unnoticed law, I'll go to the second point now. One unnoticed law in this rule is the rule 4.4, right? 4 subsection 4, which says that every e-commerce entity is to establish a grievance redressal mechanism and appoint a grievance officer. This is something in the pop culture nowadays, that anything that is online, appoint a grievance officer, right? And now understand that there is no exemption made for small businesses. There's this juice shop outside Ganesh, we call it, it's like a popular hangout spot, go have juice, that is really fun. I was speaking to Ganesh Uncle the other day, and he told me that he's probably planning to, make an online platform also, so that he can just directly interact with students through an online platform. As soon as he does that, he qualifies as an intermediary, what do you call it? An intermediary consumer, an intermediary, I'm sorry, I'm forgetting the name. It's called an intermediary seller that will become under the e-commerce rules. He will be accountable to this. Now, he has to appoint a grievance officer, he has to appoint a grievance redressal mechanism. Look at the shop size here. It's a 3x3 feet shop size, and you expect him to appoint a grievance officer, establish a grievance redressal mechanism. Understand the hardships he's going to face, understand the cost, understand the effort that he's going to take, and this is absolutely not practical. Therefore, this is a flaw that is not been much written about. I've tried to write it in my paper, and hence finally I propose that an amendment to exclude small e-commerce entities from this clause is required to protect business interests. Let me just quickly come to the data protection part. I'm running out of time, I'll just do this quickly. Understand that when we talk about e-commerce, data breaches is something that we need to be very careful about. I'll give you an example. Recently, Domino's Pizza saw the leakage of data of 18 crore customers. And I'm pretty sure 4 or 5 of you are sitting here. जिनका data leak हुआ है. 18 crore consumers lost their data, and we didn't know. It was only after the Delhi High Court had to intervene that there was some action taken here, and the data was retrieved, and the dark web was actually stopped here. Therefore, we need strong laws on data protection. The current data protection laws, there's nothing essential in India. We're talking about the Personal Data Protection Bill, which has been lingering in the parliament since like the 4 or 5 years or whenever it was introduced. There's been no substantial gain there. One solution I present to you is a comparative analysis as what as Singapore has done. Singapore has established a Personal Data Protection Commission. This body was essentially a voluntary consumer organization earlier. Imagine it is a voluntary consumer organization, a regulatory body that was not authorized, it was just voluntary. The government there identified the potential of this particular entity to become a regulatory authority, an authoritative regulatory authority, and that has been very successful. It has a very strict position now. They have a data protection policy which is very, very strictly imposed, and I talked about multiple instances as to how they've imposed fines and how that has improved. I'm not saying that we just import whatever Singapore is doing. Of course, that is not very practically feasible because we live in different worlds, but this is something that we can literally be encouraged about. Lastly, I'll just pose 2 questions, as I said, which for food for thought essentially. The first question is that when I talk about fallback liability is something that has been taken out by the new draft e-commerce rules as well. What degree of fallback liability are we talking about? Do we say that 100% liability should go to Amazon just because my product is inherently damaged? If there's a manufacturing defect, that let's say Dell has something done something wrong with my laptop, should I still hold Amazon 100% liable? Doesn't seem feasible, right? So how much liability should go to Amazon, how much proportion should go to Amazon is something that we need to consider, and very, very creative solutions can be brought about here. The second question is a major challenge that I see with e-commerce rules, is that it overlaps significantly with many other laws. The competition law is one such case. Competition law and the new e-commerce rules have very significant overlapping. If there is an issue, which court will have jurisdiction? Will it be the consumer court? Will it be the consumer commission, or will it be the competition court? Question. For example, I'll give flash sales, right? This e-commerce rules, I'll just wind up in a minute. The e-commerce rules ban flash sales, right? I hope you guys understand what flash sales are. Like, Amazon comes up with these big billion days, overnight sales, 24 hours, all stock, stuff like that, right? It bans flash sales because it sees that there is potential for exploitation. This is something that the competition law is already banning. Competition law calls it deep discounts. Now, if Amazon or Flipkart or whosoever it is indulges in such an activity, which court will have jurisdiction? Recently, if you try to just read a few articles online, you'll find out that even Niti Aayog had to intervene in e-commerce rules. Even they had a stake here. Even they had something to talk about here. So ultimately, these are 2 questions that I'll end with. These are interesting questions which can be answered through very interesting solutions, and I feel that this opens up a lot to discuss, right? And all of us as legal students, as students of law, can do a lot, because one thing that I feel is lacking in e-commerce rules is creativity, and creativity comes from the youth. Therefore, yeah, that's it from my side. Thank you so much.
Yeah, thank you, Siddhant, sorry. The next participant is Malhar.
Right. Am I audible in the back? So come, Siddhant, can you confirm?
Yeah, audible.
Right. So good morning, all of you. Rather, good afternoon. Thanks for coming down on the special festival of Holi. Happy Holi to everybody. The dignitaries on the dais, Professor Ashokar Patil, ma'am, and all the other friends present here. I take immense pleasure in presenting my paper before you, and thanks for giving me the opportunity, especially Kepler and Dr. Pratima Narayan ma'am. So to start with, my topic is the difference between harm and injury under the Consumer Protection Act 2019. Now, I would like to explore the intersectionality between the e-commerce rules and the implication of difference between harm and injury. Now, first thing to understand here is that why am I talking about the difference, right? Because it's not just of academic interest. Conceptual clarity has its own value, and it has immense practical implications in the adjudicatory process as well. Now, to start with the e-commerce aspect, I'll just give you a broad roadmap of my project. So, firstly, I'll be talking about, as I said, the intersection between e-commerce and product liability, then the difference between harm and injury, and the implication under the CPA 2019. And lastly, I'll be talking about the attempt to reconcile the difference via the canons of statutory interpretation, which is the formalist school of thought and the purposive school of thought, which also includes landmark cases in this regard, which also form the basis of product liability regime as we see today, because it is a sui generis concept, right? So I will be talking about the antecedents of the same as well. Now, to start with, the e-commerce rules under the Consumer Protection Act delineate the duties of e-commerce entities, right? And these rules stipulate the obligations of e-commerce entities, among others Amazon and Flipkart, that is popular knowledge today. And not only do these rules regulate the operation of e-commerce entities, but they're also held liable for any unfair trade practice, for example, under section 2, subsection 47 of the CPA 2019. Now, this is absolutely significant, because not only does unfair trade practice deal with these e-commerce entities, but also the positive obligations under the e-commerce rules, mainly Rule 5.2, 5.3 and 4.11. So these three rules talk about manipulation of price, obligation of taking and a seller's undertaking on the online marketplace, etc. So these are positive obligations which overlap with the unfair trade practice under the CPA. So the combined effect of these two processes leads us to deduce that e-commerce entities are squarely liable under the Consumer Protection Act. But there is one caveat, right? The caveat is section 79(1) of the IT Act. Now, what does this say? It's essentially a mechanism for intermediaries to exempt themselves from statutory liability. But as my learned friend Siddharth also said, who is an intermediary? The definition of intermediary under section 79 basically says that one who essentially disseminates information and not one who facilitates the transaction. But we know that Amazon falls in the latter category, and it essentially facilitates the transaction, and we repose our trust under the brand name of Amazon while buying the products. So there is also a fiduciary element in that relationship, which makes Amazon more than a mere intermediary, and the exemption under section 79(1) of the IT Act is not applicable, which is to say that e-commerce rules and CPA 2019 holds Amazon and Flipkart liable. Now, it's also very interesting, during my literature review and research, I was looking at how can we practically hold these e-commerce entities liable, right? During a consumer complaint, while filing it, as Professor Patil also made us do we claim our damage under the doctrine of harm or injury? Now, it's interesting that harm is defined under section 222 of the Consumer Protection Act, and injury is defined under section 223 of the same. Now, both these things talk about the subject matter is the same: damage to property, in personal injury and mental agony. The only fundamental difference is injury is a qualifier of illegality. So when an action is illegal, it falls under injury and not harm. Now, given this dichotomy, I was fascinated to see that product liability section 84 talks about harm and not injury. Now, this is significant because under the CPA 1986, you had no concept of harm. So there are two things happening here. There is an invention of product liability and another coterminous invention of harm under the same. And the legislature has not explained why the import of harm has been done in such a manner. So I will be examining this very dichotomy with the canons of statutory interpretation, right? Now, the first school of thought, that is the formalist interpretation,
says that you have to interpret the statute as the letter of the law dictates you to do. Now, what is the letter of the law? Essentially, section 222 of the Act, which says that harm is essentially an injury to property, mental agony, personal injury, illness or death. Fine, we do that. But that leads to another ambiguity. You see, the principle of statutory illegality in law says that when you violate a section of any statute, that act is inherently illegal. So when, say, a manufacturer decides to withhold relevant information to a consumer, or let's say has a very murky or inaccessible information on its online marketplace, is it harm or injury? Because that is an inherently illegal act. And what does the definition of harm says? Okay, the act is not illegal. So that leads to an inconsistency under the act, right? And the principle of statutory illegality is an instrumentality of the contracts, right? Because when you contract, and when the contract is for a illegal purpose, then it's voided at the option of the weaker party. And this principle of statutory illegality basically says that harm is injury, because violating any section of the CPA is an inherently illegal act. So why do we see a dichotomy here? Why do we see a qualifier of illegality being instituted when there was actually no need to do so? Now, I personally lean towards the purposive school of thought. But I will put my conjecture to further scrutiny by the landmark cases that I have mentioned in my paper as well. Now, another facet of my argument is whether interpreting harm as injury furthers the legislative intent of the prohibitive rule. Because the unarticulated premise behind the second school of purposive interpretation is that, yes, you have to interpret according to the legislative intent. But what is that intent? We don't know it. So, to conjecture, the legislative intent is to protect consumers from damage and to compensate them for injury. Now, this is significant because the compensation claims